Okay, so when it comes to looking at financial recovery and arbitrations, most international arbitrations these days tend to have a quantum expert involved. I'm not going to talk about other sorts of expert, but there's a need for a quantum expert, primarily because international arbitrations, both commercial and investment, tend to be all about money. At the end of the day, the client actually wants to get some money back. And it's just fairly fundamental that lawyers are not particularly schooled in quantifying money. So, and there's grown up a little bit of a mini industry of quantum experts, because we tend to know what we're talking about, whether it's loss of profits, whether it's valuations, so the standard ways of valuing things, and whether it's using the IVSC, the International Valuation Standards guidance, or whether it's following the Horseshoe Factory case. There are ways of doing things, and we tend to know what the process is. So lawyers are fairly comfortable getting quantum experts involved in working with them on the case. Right, so the question about when experts should be drafted in. Some people would always say that it's a bit, it's in our own interest to be drafted in at the beginning. But the point I would make is there are so many advantages in getting quantum experts involved in the beginning, just so you know what, so the client and the lawyers know what is at stake, know how much money may potentially be there. Because if you don't know, if a claim may have a very good valid legal basis, but if there's no money there at the end, the claimant may not actually be interested in pursuing the case at all. So the earlier, the better, even if we don't do much, even if we just advise initially on the beginning of the case and then step back, that's worthwhile. I mean, one case we were involved in, we were appointed 6 days before our report was due, and it really didn't help. We did our best, but we had to push a lot of the arguments off to the second report, which wasn't ideal, really. So the main challenges in establishing the value of the claim, I worked on a case this year, which went back 20 years. So one of the big challenges was trying to find the documents going back 20 years, and we were talking about maybe 20 different companies. So it was very difficult finding the documents. To be honest, one side had kept very good documents, and it was a company in a CIS country that had kept good documents. The other side didn't have such good documents. So that was the first challenge. I think other challenges can be language. I can speak English and French, but I don't speak Russian and Arabic, and there are lots of cases in Russian and Arabic. So again, this CIS case, I needed to rely on somebody from our Moscow office. So that would be maybe those are the two challenges I'd put forward. So novel tools in valuing claims. Well, I was thinking about this. My colleague said to me, there's nothing new under the sun. And in a way, the principles are the same as they always used to be in terms of valuing cases. So we'd be using valuation standards, and maybe international valuation standards are more accepted now than they used to be. So people know what's acceptable. I think, I mean, other traditional things like visiting the site. I did a site visit a couple of months ago, and it's always so valuable to visit, even as a quantum expert, to actually see what's happened. That's useful. The only innovative thing I can think of was more use of data analytics tools. So the ability to drill through a vast quantity of data, whether it's on an SAP type system, and look for things. And so we can use questions and interrogation now of vast amounts of data. So I would say that's possibly the one new tool. But otherwise, it's just using efficiency and knowledge of how the process works, and working very closely with the lawyers. I would say also just working closely with the lawyers and being trusted as part of the team. I think those are some of the things that are good.